Hello, Albert. I need a lawyer, and you are smart, so I figured you could help me.
Well, Leonardo, I am actually a physicist. But I can probably help you. What do you need?
I want to sue AT&T. They are being jerks and cutting back my data speed. I think they are racist.
Why are they cutting back your speed?
I have an iPhone, which is awesome, and I pay for unlimited data, but they slow down my speed after using up 5 gigabytes.
Why are you using so much data? What have you been watching, Leo?
Don't worry about it.
I'm afraid I cannot help you. I am not a lawyer. If you need a lawyer, go get OJ's or Casey's. I hear they are pretty good.
No, I did not murder anybody. I only need some advice. Can you help me sue AT&T?
Well, I wish I could, but I am afraid you can't sue AT&T.
Why the bloody heck not?
Because those smart SOBs put something in the contract that you signed. I think it says that both agree to resolve disputes through binding arbitration or small claims court instead of in courts of general jurisdiction, which means that you cannot sue them. You can only challenge them through arbitration. Kind of like when you get into an argument with a friend and you go to another friend to see who is right.
Except that here, your friend is a billionaire with lots of lawyers and I am just one tiny consumer.
Exactly.
Is that legal? My friends Donatello, Michelangelo and Raphael also want to sue AT&T. And I was kind of hoping we could sue them together.
Well, the way AT&T has it set up, you cannot do class action lawsuits. And yes, it is legal. In 2011, the Supreme Court ruled in favor of AT&T in AT&T Mobility v. Concepcion.
What? Why? Tell me more about that case.
Well, in 2006, Vincent and Liza Concepcion sued AT&T in California over a dispute over their phone contracts. AT&T often advertises that they will get a free or reduced price phone with a new 2-year contract or a 2-year contract extension. While the phone is oftentimes free of cost, the consumer must still pay for the sales tax of the original value of the phone. A new 32-gig iPhone is $750. With California state sales tax of 7.25%, not including local sales tax, comes out to about $55. The Concepcions argued that this was false advertisement and sued AT&T in a California federal district court, and the case quickly became a class action lawsuit because others felt the same way. AT&T then asked the court to dismiss the case because the consumer contract that each customer is required to sign clearly states that they will solve disputes through arbitration, not through lawsuits.
Well, if the court dismissed the case, why did you say that the Supreme Court ruled in favor of AT&T?
Because the court did not dismiss the case. The California federal court refused to throw it out because of the 2005 case. Discover Bank v. Superior Court, which outlawed arbitration clauses in consumer contracts because it would eliminate small class action lawsuits by consumers, thus making it much more difficult for consumers to challenge big corporations.
Then what did the California court say? Holy cow, were those gunshots?
Yeah, we share the building with a math lab. It happens pretty often.
You mean meth lab?
No. I'm pretty sure they said math lab. That's why I chose this place. I figured I would fit right in. Anyways, there were conflicting views. Some said that Discover Bank v. Superior Court allowed the Concepcions to sue AT&T. There was a case in 2005 called Schroer v. New Singular Wireless Services. That case was also about the arbitration and the banning of class action lawsuits. In this case, the court ruled that the clause was unconscionable.
What does that mean?
Unconscionable. It means not right or reasonable.
Okay, then what happened? It seems like it was a pretty easy ruling.
Well, others say that Discover v. Superior Court and Schroer v. Singular went against the Federal Arbitration Act of 1925, and Article 6, Section 2 of the Constitution is the supremacy clause, which says that federal law shall triumph over state law.
I'm guessing that act made arbitration legal.
The FAA says that a written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract.
Albert, I am a painter, and an engineer, and an architect, and an inventor, and a scientist. But I am not a lawyer.
It basically made arbitration a legal method of settling disputes.
Anyways, what happened next?
In 2010, the Supreme Court decided to accept the case, and in 2011, they came out with a ruling.
Well, what did they say?
Are you stupid? I already told you that they ruled in favor of AT&T.
Well, yes, but why? And I am the stupid one? You are the one who is sharing a building with a meth lab.
I already told you, it is a math lab. And it was a 5-4 ruling. The majority opinion basically said that it would be stupid to think that people would challenge the corporations without some sort of plan. They must have a plan of attack or else they would not challenge. They also said that class action suits go against the basic theory of arbitration.
That's dumb.
Yeah, I know. The dissent did say that it is not up to the court to say that arbitration does not rule out the possibility of a class-wide arbitration ruling. Without class action suits, minor frauds would go unpunished. The consumer is much stronger together than separate.
Like killer bees?
Yeah. Like killer bees. In the aftermath of the ruling, many experts said that this ruling marked the end of class action lawsuits against corporations. This one guy did manage to win his arbitration against AT&T.
What happened to him?
What do you think? He switched to Verizon and got $850.
$850. Thoughts not much.
Pardon me, that was my cell phone.
Why didn't you answer it?
'Cause it was probably on replay. He keeps asking me to finally admit that I stole his theory of relativity. Like that's ever going to happen.
Okay, well, I better go. Thanks for the help, Albert. Oh, by the way, I would take a look at that math lab of yours.